Hi, everyone. Welcome to this spotlight event on ending the IPP sentence. Thank you for joining us. My name's Andrea Coomber, and I have the great privilege of being the Chief Executive of the Howard League for Penal Reform. This event is sparked off by the fact that last week we launched a report of an expert group headed by Lord Thomas of Cwmgiedd on how to end the ongoing impacts of the IPP sentence for good. And so that's what we're going to talk about today. And just looking through who the participants here are, I know a lot of you know an awful lot about, from personal experience in many cases, about the IPP sentence. So I look forward to a really rich discussion today. First of all, some housekeeping matters. Basically, the most important thing is the spotlight event is being recorded. So there we know that there are some people who would love to be here today but can't be because of they're busy at a lunchtime on a Wednesday, so that's so they can watch this later. Please use the chat function at the bottom to the right of your screens to introduce yourself and to provide any comments or thoughts. But please reserve questions because there'll be an opportunity to ask our panel questions for the Q&A box, because it's quite tricky, having done this a number of times, quite tricky to monitor the Q&A and the chat box. So we'll only be answering questions that are put in the Q&A box. Typically at these events, people don't ask too many questions until 10 minutes from the very end, and then we are inundated and can't answer them all. So please do get your questions in early. Also, one weird proviso is that I was half an hour ago told that I'm going to get a delivery of some chairs that will be arriving between 1 and 3. I very much hope that they'll be arriving closer to 3, but if I disappear briefly, I'm just letting in some delivery men. So apologies for that. The Howard League, as you probably know, has been around for a long time. One of our strategic objectives is the ending the IPP sentence and the legacies of that. And we have a large membership, including more than 100 people still serving an IPP or a DPP sentence, that being an IPP that was given to children. And we have many more members in the community, including many people who are here today, who are still have on the licence or have been on the licence for of the IPP sentence. So thank you for joining us. Literally every day we receive mail from people serving IPP sentences or in prison, or from family members, or from people in prison, not on an IPP sentence, but expressing their concern and upset for their fellow prisoners on wings who are serving this sentence. And I don't need to tell the people in this audience just how unjust this sentence is and how it continues to blight and ruin lives of individuals and their families. And so at the beginning of today, I want to spare a thought for all those people who are in prison on this awful sentence, for their families, and for those people in the community with the threat of recall hanging over their heads, and all of the stress that that brings. I'd also like to spare a thought for the 170 odd people who are still serving a pre-IPP 2-strike sentence, who have spent even longer in prison than people serving an IPP sentence. And while our report makes passing reference to that and doesn't speak directly to that group, we will push for recommendations to be read across where that's relevant for those individuals who we do worry about enormously. And again, we have lots of them in our membership. As you probably know, in 2022, the Justice Select Committee launched a scathing assessment of progress of release of people on the abolished IPP sentence and called for a resentencing exercise and the establishment of an expert group to advise on resentencing. The government at the time made it clear that it would not be resentencing on grounds of public protection. And in July last year, the current government made its rejection of resentencing very clear. There was, at the end of last year, a significant reduction, middle of last year, a significant reduction of the licence served by people serving an IPP sentence, something that Howard League with others had been pushing for many years. And that's reduced the time that people serving the sentence need to spend on licence in the community. It also introduced an automatic sunsetting of the sentence, providing relief to very many people. But it didn't provide relief to those who'd never been released. And so at the end of last year, in light of the rejection of resentencing, we formed an expert group led by Lord Thomas to come up with a lasting solution to the IPP crisis. And I'm very grateful that Lord Thomas is taking time to join us today. along with 2 other people who served on that expert group, and will speak to his recommendations. That's Dr. Laura Janes and our rapporteur, Claire Salama. And I'm also really delighted that we're joined by Marc Conway, who has had personal experience of dealing with this sentence. So without further ado, what we're going to do is we're going to have presentations of about 5 minutes from each of our presenters, followed by a short panel conversation, and then questions from you. So please do put your questions into the Q&A box. But first of all, to talk about why this sentence why this all matters, and somebody couldn't be more qualified for that, is Marc Conway, who's formerly worked at the Prison Policy Network at the Prison Reform Trust, is involved in the fantastic work of UNGRIP, and is now the Director of Fair Justice. Marc.
Thank you, Andrea. So firstly, thank you for inviting me on such a real important topic. Now, if I was going to introduce myself a few years ago, it would have been Marc Conway, A1980AQ, IPP prisoner. Now, when I look at my journey, I got a 5-year IPP. I was released after 8 years. I'm one of the lucky ones, and that was quite bittersweet for me. Last year, my licence conditions was overturned, and again, that was very bittersweet because yes, I was happy that I was no more held by the restraints of the IPP sentence. However, there was hundreds, thousands of people left behind, which I had served with, that I speak to, that I had worked with, and we're talking decades and decades. So the question is, why is it important to end the IPP? The fact that it was abolished in 2012 and we're still having that discussion should say it all. That's why it's important. We can say that, you know, IPPs have the most highest rates of self-harming, death by suicide. That's why it's important. But the wider public, the government, it doesn't really hit home when it's about people already in prison, about people that have committed the crimes. So what does it mean to the prison service if the IPP sentence was gone? There was no more IPPs. Well, we're in a land and we're in a time where overcrowding is massive. Freeing up these extra spaces is quite contradictory, and it's quite humorous the way that people are banged up in prison for public protection. But the best way to protect the public is when people go to prison and they're released, that they don't commit crime no more. With all these IPPs still in prison, 2,700 there or thereabouts, resources are being taken. So the resources can't be put into reoffending, so people get out and commit crime again. So actually, it's actually contributing, by keeping these people banged up in prison, it's actually contributing to more and higher crime rates outside. What does it mean to the general public? Like I said, actually freeing up prison places and resources protects the public. You know, that sounds a bit weird to the people that don't know about this kind of thing, but we're all singing off the same hymn page here. So for the prison service and members of the public, it is vital that the IPP sentence is ended and taken away. But if we look on a more personal matter, it saves lives. It will save lives. People are committing suicide. People are committing self-harm. The stress that it has on family members contributing to ill health. I'm free of the IPP sentence, but until this sentence is fully gone, it affects my PTSD, it affects my mental health. I'm still, in a weird way, living under the restraints of the IPP prison sentence. Yes, maybe because I do it for work and I'm speaking to it all the time and stuff like that, but I can't be fully free. So it's not only impacting people that are serving, it's also impacting people from the out. I do a lot of work in prisons. I speak to prison officers. The mental health stress and impact and health impacts that it's having on prison officers of working with people who are serving this sentence, the large number of prison officers that gave up within the first 12 months of joining the service. I've spoken to a few. They have all said the IPP sentence was a massive contributing factor to that, because they didn't want to work in a system that was treating people and keeping people decades and decades over their talent. This whole issue has a wide-ranging effect. on just not the people serving, not just their families, but the whole system. So just before I wrap up, why is it important to end the IPP sentence? 1, because it benefits the prison system. 2, because it benefits the public. It benefits the prison system with the people that work in the prison system as well. 3, because it benefits people serving the sentence, it saves lives. And 4, because it's the right thing to do. So if you were in an occupation, well, it's all good that people are singing off the same hymn sheet on here, but sometimes that isn't just enough. If you know people that can make changes, write to your MP, get people that ain't singing off the hymn sheet on board. If you fail to do that, then you're part of the problem. So shame on you. Again, the reason why it's important to end this IPP sentence is because it's the right thing to do. Thank you.
Thank you, Mark, and thank you for sharing your experiences with us. The idea that it is with you is a further indictment of the sentence. And I think worth noting that all those people that Mark's talked about, the prison officers, prison governors, everybody, I think, who works around and with people in IPP sentence understand that it needs to go. Like, it is one thing that brings everybody together, is a common understanding. But that was very powerful. Thank you. Our second speaker needs probably little introduction to a Howard League audience, but is a consultant solicitor with GT Stewart, leading prison and parole lawyer, formerly legal director of the Howard League, who earlier this year was appointed Honorary King's Counsel, which is a weird little thing. I say, having done it myself, for her outstanding contribution to the development of law in England and Wales, and was a very key contributor to our group. Laura's going to speak about 2 of our key recommendations.
Thank you very much, Andrea. And I just want to start really by thanking Marc for sharing his own thoughts and experience. And as you say, the shadow of this sentence continues. And the million-dollar question, of course, is, because it is the right thing to do, how on earth are we going to do it? And I hope that this report really goes some way, because it's really practical. And I have 5 minutes, which is even less than the time I was given in the House of Lords launch the other week, to describe not 1 but 2 of the most complicated recommendations. So I'm going to get straight to it. And it's back to this issue of time. Marc mentioned this idea of this sentence going on and on for decades, even with these short tariffs, these short minimum terms. And the question I always get asked, and every lawyer gets asked, the first and most important question is, when will I get out? But the problem, of course, with the IPP sentence is that the answer is, I don't know. It's uncertain. And it's that uncertainty that breeds the hopelessness, that explains, I think, in some ways, why the self-harm rate among people on IPPs is twice that of those with people on life sentences. And just to give an example of one of my own clients who got an IPP sentence as a child, DPP, detention for public protection, at the age of 15 for under a year. And the judge told that child, you will be out before your 18th birthday. And no doubt he really thought he would. But unfortunately, he served that minimum term 25 times over, first released in his early 30s. And then now, still under the shadow of the sentence. So it's that hopelessness that creates the terrible legacy. So the proposal we have here is to create a very firm and safe legal framework that will change all of that. And the idea is very simple. At the moment, the parole board test is, right now, is this person safe to be released? And if you take that pure question, often the answer will be no, for all sorts of complicated reasons. What we have proposed is that you modify that test. Instead of saying whether, the parole board will ask itself when, within the next 2 years, if not now, obviously if they're suitable now, good to go. But when, within the next 2 years, will this person be safe for release? And what do we need to achieve that safely? back to that public protection imperative that Marc just talked about. And the idea is that this will create a level of certainty and clarity, both for the people on the sentence, but also for victims and the people who are in charge of supporting them through the pathway to and on release. And it builds on the strengths of the parole board. Having sat in many, many parole boards over the last 20 years, you know, I can see for myself how good many of the parole board members are at managing people out. But they're not really supposed to do that under the current law. They know exactly what assessments are needed, what work needs to be completed, and critically, and I'll come back to this with recommendation 4 in a second, what support is needed in the community. But currently, they are legally restricted from using all that skill and expertise. They can't set goals and review them, whereas under our proposal, they'll be able to do exactly just that. And the system will have, because public protection is of course important, some safeguards built in, not just for the public, but also for the person concerned as well. So if that person makes unexpectedly good progress after 6 months, they'll be able to apply to bring that date forwards. Equally, if there are some really serious concerns that have developed since, then we have all sorts of mechanisms, including the setting aside mechanism, which can be extended to enable the Secretary of State to make a relevant application so nobody is put unnecessarily at risk. But all things being equal, there will be light at the end of the tunnel and a level of certainty. Now, when I mentioned what needs to happen in order to secure that safe release, I talked about assessments and work being done in prison, but I also talked about what support is needed in the community. And that brings us on to recommendation 4. This again is another very simple recommendation, and it builds on another very well-established process. It's borrowed from the world of mental health, which I'm also a practitioner in, and it's been developed actually because of the young man that I just mentioned. The biggest issue that I see as a lawyer in getting people out in the first place and then keeping them out is they just do not have enough of the right kind of support available to them. So in order to get the young man out that I mentioned earlier in the first place, things had to get so bad that he was sectioned in a mental health secure hospital. Then he returned to prison, but by being sectioned, he became entitled to something called Section 117 aftercare. Okay, and that is a statutory duty on both health and social care authorities to put in place wraparound support to make sure that his mental health would not deteriorate again to that extent. And that meant that in all the years I'd been supporting him up there, I never had anything other than a sort of 3-month AP placement, and it was never going to be enough to meet his exceptionally high level of needs. But it meant that when he went back to prison from hospital at his first parole review, I had a therapeutic, supported living placement with occupational therapy, psychiatric oversight, access to mental health, sort of all sorts of support with medication, support with getting work, and he was released. And of course, as is understandable after you spent over half your life in prison, he did fail, but that support remained in place, and he was re-released again following that first recall precisely because that support was still there. And now he's coming along and doing talks with me and you know, and thriving. So it was very clear from that experience that you shouldn't have to end up on a long-term section in mental health hospital in order to get that level of wraparound support. So it's about having holistic support that goes above and beyond a standard AP, friends, family, third sector engagement. Now, not everybody is going to need it. And in fact, hopefully most people won't need it. But for those who do, for whom it's very clear that 3 months in an approved premises is not going to be enough, what we're proposing is that there should be an equivalent duty to provide those people on IPP sentences with that kind of support from health and social care. And it will be voluntary, it will be needs-led. The costs will be spread across both health and social care, but also geographically across the country. It builds on a process that happens every day for tens of thousands of people leaving mental health institutions, and it will create a level of long-term care where needed to unravel the long-term harm caused by the sentence.
Thank you, Laura. Masterful as ever to get all of that into 5 minutes. And I think really drew out the fact that the recommendations in this report are based on established, evidence-based things that we know work, that are already available, where there is already existing expertise and an evidence base to provide protection to the public, but also support to people on the sentence. We've not reinvented wheels here. Like, these are, this is very solidly led by existing practice. If you have particular questions for Laura, please drop them into the Q&A, because she is going to have to leave us slightly earlier than the 2:15 deadline. So please do address any questions to her before kind of 1:50. Our next speaker, who I'm afraid is speaking in 5 minutes about 4 recommendations, is one of the 2 managing solicitors at the Howard League, where, amongst other things, she leads on the IPP sentence. At the end of last year, Claire Salama, our next speaker, led the creation of a legal guide on the IPP licence changes, and then trained a cadre of lawyers from Peters & Peters law firm in those changes, with a hotline that advised more than 100 people on the licence changes, and family members and those working, professionals working with people on IPP sentences. And a couple of weeks ago, that project won a highly commended award at the Lawyers Magazine Excellence Awards, where we sat through a very weird ceremony, but wonderful, but also weird. So Claire, would you like to talk to us about the other 4 recommendations, please?
Thanks, Andrea. So Laura spoke about the key need of certainty of having a release date, but without changes to the recall process for people serving IPPs, we're going to see the numbers in custody remain pretty steady. And that's because we know that the number of people serving IPPs being recalled is increasing year on year. And in 2023, there were 658 recalls. And that's many where the link for recall has been tenuous, with a failure to differentiate between rule breaking or poor behaviour with a risk of harm, leading to too many recalls for administrative breaches of licence conditions. So, for example, the working group heard about probation areas where there were blanket policies for recall where an individual is late for an approved premises curfew. There's this just in case overzealous attitude used in the absence of exploring alternatives to recall. And we know that the problem is, once recalled, they end up spending months or even years back in custody. Of those 658 recalls in 223, only 448 of them were re-released at their first review by the parole board, having spent an average of 27 months back in custody first. And others require multiple reviews over years by the parole board to be re-released. So our expert group recommendation 2 tackles 2 systemic failures in relation to recall. 1, a recall threshold that's too low and loosely applied, and 2, zero independent scrutiny before recall bites. So we came up with 3 reforms. The first is to enforce a more rigorous causal link test. That includes no recall for licence breaches alone, only if there is evidence that the behaviour links the behaviours in the index offence and poses a significant risk of harm. 2, a licence breach to trigger a review of the licence by probation to see if any tweaks can be made to community support or adjust risk management plans and explore other more quick fixes like medication changes or return to approved premises. And out of hours recalls being saved for true emergencies only, the expectation that they can be dealt with by the individual's assigned probation officer the next day. The second reform is to end recall as a default response to an arrest. for courts to deal with further allegations in the first instance outside of the recall process and let the law take its course. The third reform is about having independent pre-recall scrutiny, a kind of three-stage triage to confirm probation's decision to recall, to determine if the person serving the IPP sentence can resume their license or really does need to return to prison. So this would include a strengthened PPS SIFT, second stage being a review on the papers by a judicial parole board member or a district judge. And thirdly, if a decision on the necessity of recall could not be reached on the papers, to convene an urgent hearing. And meanwhile, in the interim, the idea to keep individuals in the community, perhaps on enhanced reporting, preserving their approved premises, jobs, benefits, etc., and decreasing the interruption to rehabilitation unless recall is confirmed. As we've mentioned with the other reforms, it's all crucially using existing processes, and there are careful safeguards within there to answer the public protection queries of the government. I'll briefly touch on the other two recommendations. The next one is about reintegration and rehabilitation. This is recommendation 3. And currently, under the Rehabilitation of Offenders Act 1974, indefinite sentences are never spent. And we recommend that, unlike other life sentences, IPP sentences can become spent using the term of punishment imposed by the sentencing judge as the relevant sentence under the Rehabilitation of Offenders Act 1974. To give an example, unless the individual serving one of the excluded offences, a person serving an IPP with a tariff of 4 years would have their conviction spent after the 4-year tariff period and the further 4 years. That would increase depending on the length of the tariff. This would result in some individuals not needing to disclose their conviction on a standard record check. Disclosure would also always be required for people wishing to work with vulnerable or young people. And the idea is that it offers a chance for people to reduce the barriers in the way of employment or getting insurance or becoming a volunteer, and help to reintegrate better into society. The final recommendation is to restore annual licence termination reviews. So we saw a lot of progress for licence termination in the Victim and Prisoners Act 2024. But one thing which we have seen kind of as it comes into play, especially through practical examples with individuals in the community, is an element where the Act removed the element of an annual review by the parole board after the qualifying period. So sorry, they removed the annual review in favour of a one-off review by the parole board after the qualifying period. And these changes have been quite difficult and problematic for those who struggle most being on licence and might find themselves kind of returning back to custody very quickly after release, and those with the most chaotic or unstable lives. Our recommendation is very simple on this one. It's to return the right of an annual review to the position that existed before the amendments in the Police, Crime and Courts Act. And that would allow an additional opportunity to apply to the parole board annually to review the licence to see whether it was needed. I said that was my last recommendation, and it's not. That's not to say that the actual last one is not equally important. But this last recommendation 6 is an enhanced approach to criminal appeals. So there have been some successful appeals against IPP sentences, but we also know that there's lots of people who haven't tried to appeal because they're not aware, or that they haven't got the further evidence, for example, that they needed at the time that they looked in the first instance. So this recommendation is just about removing some hurdles for bringing an appeal by creating a positive obligation for every person serving an IPP to have access to a special CCRC, it's a Criminal Case Review Commission process, which can expedite their application to the full Court of Appeal Criminal Division to appeal their sentence. And that would include prioritising those unreleased and most over tariff and supporting individuals to be legally represented. In short.
Thank you so much, Claire. So again, another 4 recommendations, a critical one around recall. And we know that we now have many more people in prison and IPP sentence who've been recalled than those who have never been released. Our final panelist is the man who has anchored this work. Lord Thomas is a former Lord Chief Justice of England and Wales, obviously a former senior judge, now serving in the House of Lords, where he is outspoken on the ongoing injustices of the IPP sentence. Lord Thomas. You're muted. Unmute yourself.
What an auspicious start. First of all, may I thank both Claire and Laura for their very clear exposition of the report. Why are we putting this forward? I think there's one answer to that, and that is to achieve justice for those who did not get justice when the reform was made in 2012 and this sentence brought to an end. And I think it's important to recall why the sentence was abandoned. It was an experiment essentially with preventive detention, that you didn't keep people in prison for punishment and for rehabilitation, but you kept them there until they were deemed to be safe to be released. And it proved to be an experiment that was one that did not work. There were a number of reasons for that. Partly it was due to prison overcrowding, but fundamentally because it's extraordinarily difficult to predict future behavior and to keep someone in prison until you are in a position to judge whether they're safe or not is almost something that's impossible to do. But the difficulty that we had with the reform, and there was no carry through to those who had been subjected to the sentence, was that the same reason for ending the sentence for the future was not applied to those who are in prison. And they have remained for over 12 years now the subject of this really unjust and what has proved to be unworkable sentence. And it's time, surely by now, that justice should be given to those. And I think you can test this most easily by looking at the position of those who happen to commit virtually similar offences. No offence is always the same, but almost indistinguishable offences before April 2005 when the sentence came in, or after December 2012 when the sentence went out. They're given determinate sentences with a period of time limited, an extended sentence of supervision in the community. But for them, all sentences, whether they were sentenced before 2005 or after December 2012, have a finite end. And it is simply unjust that this group of people who happen to have committed offences and been sentenced in the 6.5-year period are subjected to a form of punishment that we recognise to be wrong, and there can't be any justice in allowing this to continue. Several have pointed this out over the years, and I think everyone accepts that this is a stain on the reputation of British justice. Now, why, therefore, doesn't the government abolish it? And I think there are really one reason that is given. They say, well, these people were deemed to be dangerous by a judge all those years ago, and they're still not safe. Therefore, we should keep them until they are safe. Well, the first objection to this is the one I've already outlined. It perpetuates the fallacy. Secondly, it doesn't address the issue of injustice. Thirdly, it doesn't address really important practical problems. First, as Laura has explained, there are means of, if you put your mind to it, dealing with people in the community. And there is, I'll come back to the risk element in a moment, but there is no reason why, given a different approach to the way in which you train and rehabilitate, we can't move safely to that. The fourth reason is the system of recalls. In the case of a determinate prisoner, I can see the argument for saying, well, he's been allowed to serve part of his sentence in the community. Therefore, if he does something that risks harm or is wrong or is an infraction of his license, well, let's recall him to prison where he can continue his punishment. But of course, those who are on IPPs are in a completely different position. They've done their punishment by serving their tariff term and are being returned to prison at a test that is far lower than that which was imposed by the judge. When the judge sent them to prison and for preventive detention of this kind, it was because they pose a significant risk of serious harm. But if they're being recalled to prison, there really just has to be a risk of harm. Theoretically, there ought also to be a causal link with the offence, but it's fairly clear that in most cases that is not the case. And so you have an enormous unfairness in the recall system, and it really is imperative that that is changed as soon as possible. And the next reason to give is that when you look at the argument of the politicians who say they shouldn't be released, you then have to ask yourself the question, well, look, the public accepts those who committed the offence before April 2005 and those who committed the offence after December 2012 have some risk of committing a further offence, but we accept that. Why is it different in respect of these people? And that takes me to the seventh reason. And you can say, I think there is some ground for saying this, that actually locking people up without giving them a release date makes them more dangerous. Now, it's possible to say, well, that's tough. But who made them more dangerous? And that is plainly the state. They made them more dangerous by devising this form of punishment, perpetuating it beyond 2012 for the others. And if there is a responsibility that because we've locked people up for too long, that is the state's responsibility. And the state should bear that responsibility by A, acknowledging it was their fault, but more importantly, by providing the resources necessary if the kind of support in the community is to be given. It seems to me, therefore, that what we're really here dealing with is a question of fundamental justice and fairness. And I have a great faith in the British public. You look at what happened to the postmasters, that was regarded as the most outrageous conduct by an organ of the state. We've simply got to get people to appreciate that those who are subject to the IPP sentence are in a similar position of having been most unjustly treated. It's going to take a lot of time. We've got to show people that there is no danger, and I don't believe there really is, having seen what many of these are like. And therefore, although it's going to be a struggle, I very much hope it's a struggle that can be won.
Thank you, Lord Thomas. Maybe I'll come back to this before we've actually got nearly to our question time with the audience. Maybe I'll come back to Marc for some reflections on what you've heard about the report and on Lord Thomas's assessment of how we've got into this.
Yeah, I think with what Lord Thomas was just saying, people serving this sentence, they actually speak about this type of stuff. This is what they say. They say, you know, if what creates the feelings of loss of hope and that you're feeling left behind and you're being treated differently is someone who's committed a similar offence. I agree with Lord Thomas, no offence is exactly the same, motivations, reasons, outcomes, but someone that's committed a similar offence, probably with a worse criminal record than you, gets a totally different sentence and then goes home, not just a day, weeks or a year before you, but decades. that creates a real unfair balance within the criminal justice system, a system that supposedly on the tin says it's fair for all. Also, I totally agree with what Lord Thomas said about the state's responsibility. This is something that I've said previously, that you place people inside an environment that actually makes their issues, risk 10 times worse than what it was when they came in. Then that's on the state's shoulders to deal with. Firstly, to take responsibility for, and secondly, to actually deal with. And by keeping people banged up for longer periods, that's not dealing with it. That's actually making the situation worse. I think I love the recommendations regarding the automatic 2-year thingy and stuff like that. I think that's really important. I think also I like the idea about the appeal system. You know, every other person has got a right. Every other person that's been in the criminal justice system has got a right to appeal, but it tends to, when it comes to IPPs, it tends to be a right to boot subject. I think what the government should do, and on that runs alongside the recommendations, is that there should be an automatic appeal system. You know, some common sense should prevail, but as we know, within a criminal justice system, common sense just isn't that common, and sadly, it should be. So I totally agree with the recommendations, and I 100% agree with what Lord Thomas said about the state taking responsibility now, rather than just pushing it to the side and coming out with these it feels like they're do-good gestures. We're trying to do something, but they could do a lot more.
What are the do-good gestures? I don't see.
So the do-good gestures would be, we've set up a IPP action plan, and we have full faith in it, and we're trying to deal with this. We put an action plan together when people that are in the know the action plan's probably not even worth the paper that it's written on, and that's not through the motivation of trying to make it work and with the good intentions. I would suggest it's more to do with people in prison can't even get to order roll. You can't even get the basics right in prison. How the hell are you going to implement an action plan where people need to be in the right places to do the right courses if people can't even get to order roll? You know,
Yeah.
it is.
I mean, it is one of those things where, I mean, look, Mark and Claire and I will sit on the IPP Action Challenge panel for HMPPS for the prison service, and you know, I think, you know, there's a lot in the action plan that is good. It's you know, overdue, perhaps some of it, but it's good to see there being those actions. At the same time, this is a prison service that is already, you know, pretty much on its knees with overcrowding. We know that, you know, people can't be in the right prison because the prison service is trying to just find beds for people on a nightly basis. It's I think just unrealistic to expect the prison service to be able to deliver this particular cohort of people who with every year are just more and more damaged, as has been explained by the sentence itself. It's not to do with dangerousness of index offences at all. It's to do with the way they've been treated by the system. And to expect the prison service and the people who work within it doing their very best in this particular context to be able to deliver those people ready for release to the parole board on the current test is just completely, you know, unfair, I think. You know, we need to free up these spaces, as Mark suggested, for an overcrowded system, because these people, you know, all but I think 6 of them are now well over tariff. Enough. Laura, perhaps we will go to questions from the box. There is a question of clarification here about recommendation 1. So I thought we would come back to you on that. It was from anonymous attendee at 1:35.
Okay, let me just have a look. Perhaps.
So basically is a concern about, you know, if people, I mean, I can answer it, but it's better for Laura to answer it. If the parole board suggests that somebody has to do X and Y before they're released in 18 months' time, and that doesn't happen, does that then mean the person is kept in prison indefinitely? Is the question.
No, I think that the imperative here is that the parole board would be saying, this is what you need to be doing. It would be based on evidence at the hearing, and there would be an action plan to make that happen. And the parole board would actually be able to have check-ins, so case conferences, to make sure everything was on track. The problem at the moment is what we have is sort of vague ideas. Oh, you should do a course, and one professional witness will say you should do this, and then the problem will say, well, that doesn't cut the mustard, right? So the idea is that the decision maker is saying this is what you need to do, and then there's an imperative to get it done, and an imperative on the state to supply it and provide it. If obviously somebody is offered a course and they refuse to do it, or there's a new situation, that may be different, but it's got to be clear stepping stones towards release. And of course it chimes very much with the whole new ethos from the Gork Review, which is, you know, incentivizing and being straight talking and making sure you give people proper options to progress.
Thank you. Other questions in the question box? Another anonymous attendee has said they struggle to find why the government would still uphold these sentences, considering the impact it has on individuals and resources of prisons. Do you think there may be reluctance due to refusal to accept wrongdoing and considerations of human rights? I mean, I think the answer to that is that the government recognises that it was right to abolish the sentence now. I think it's, as Lord Thomas has said, it's the fact that we haven't been able to find a path beyond on how to do that. Sorry, as Laura said, it's a question of finding a way to do that. I mean, undoubtedly, human rights are being violated, as Lord Thomas has said, a form of preventive detention. But unfortunately, declaring something preventive detention doesn't provide a pathway out for those people who are still on the sentence. So that's what hopefully our recommendations have been able to do. There's a question here, maybe Lord Thomas, you're best to answer it, around the government being brave enough and bold enough to be able to do this. Do you have any thoughts on, you're going to have to unmute yourself again.
Which time is that?
It's one of the top ones, towards the top, second from the top. 121.
I think the two answers to that. First of all is what I said, and I don't want to repeat myself, which is that the difficulty that is faced with politicians is that when the parole board refuses to release someone, or would be given a time frame in which release, the answer must be, well, surely public protection is the number one. And I think the way to address that concern is, first of all, to show that actually if you give a timescale and a plan, the risk is very, very significantly reduced. And secondly, to really push home that actually one of the great hallmarks of our country is we believe in justice. We have institutions that are meant to uphold justice. And we should pride ourselves for the reputation of our entire country and of our justice system that these 2,500 people really require justice. But the politician will take the view, I suspect, unless pushed hard, well, we've got so many other things to do, and there is the risk of danger, why imperil ourselves? That would be a stock answer they would take. I sincerely hope, and we shall push them as hard as possible to actually be bold, be brave, and to do what is right, because the risk is minimal.
Yeah. Laura, we're about to lose you, but I wonder if you want to answer the question around the intersection of IPP sentences and autism and the parole board, and you have to unmute yourself as well.
I will unmute myself, but sorry, I was looking at the chat before. This is on the questions.
Sorry, this is at the Q&A.
Time is that?
128.
128. Yes, so this is from Melanie, and it says that she's observed that a considerable number of IPP prisoners are autistic. Also, an observation that I've shared. Even when this is documented, the parole board does not seem to take the reasonable adjustments into account. And how can we flag this up better? So really, really important point. And I have to say, actually, I've found that if people have appropriate representation, the parole board can be really receptive to making appropriate, reasonable adjustments to people with autism. But actually, I think in some ways it's about recalibrating the risk management and what's expected of an autistic person, and detangling risk from symptoms of the autism, and actually risk management, people more broadly adapting their needs. So I think that this kind of new process would be perfectly designed to take all of those issues into account. Certainly, you know, it's something I think that the parole board, they've developed this sort of trauma-informed guidance and special guidance on neurodiversity. So they are very much aware of the whole spate of issues in relation to neurodiversity, but it needs to be a root and branch approach. And I definitely think that one of the benefits of having this process is you'd have a cohort of members who are sort of working on this, and they would really need to be across issues about neurodiversity, both in terms of what work they're setting, what the targets they're setting are, and what the needs in terms of the risk management are. And they can be asking for autism informed evidence before them to make sure that's appropriate. So thank you for flagging it up. Really important issue, something I think the parole board's well placed to deal with, but something we should push on more.
Thank you. And thank you to Laura. Laura now needs to leave us, but thank you, Laura.
Thank you very much for having me, and look forward to hearing about the rest. Okay, bye-bye.
Thank you. Claire, there's a question here about recall changes. Oh, yes, about whether they would apply to other sentences. Again, that's quite simple, but I'll leave you to answer.
Yeah, I mean, the recall test for IPP sentences is supposedly a higher threshold than for others. This causal link is not within the recall for standard determinate sentences, for example. What we think we see is that causal test is not always being applied. So the recommendation, the reform around the causal link, no, would be very specific. But for the other recommendations in terms of, for example, letting the law take its course for further allegations, yes, could apply more broadly. Don't see why it couldn't. I mean, actually, in the Gork review, what we've seen with their proposals around reform for recall of fixed-term recall for standard determinate sentences actually goes further than what we're suggesting here, and would be releasing all of those sentences without further review by the parole board or consideration of their risk. So we are not trying to eliminate recall, just make it tighter.
Thank you. There are a number of questions here from Adrian. I don't think we'll be able to get through all of them, but one of them is about, it's unfortunately so big a question, Adrian, we can't possibly answer it, which is how can we replace as much prison as practical with rehabilitation and positive holistic measures comprehensively and everywhere? That is obviously would be in everyone's best interests, but I'm afraid that's for a bigger, frankly, much longer spotlight event that we could perhaps do at another time. But that would call for a fundamental recalibration of the way that penal system works in this country, much as that's something the Howard League has been urging for 159 years. But I completely agree with the sentiment. There's also a question here from Alan. I mean, I think this is an interesting one because it's about the IPP prisoners who are reluctant to engage in processes. And I mean, I spent a lot of time going to jails, have gone to a lot of IPP forums in the last 6 months. I mean, I always go to them, but have gone to a lot of them. But equally have asked to speak to IPP prisoners who are not attending the IPP forum. IPP people who are serving an IPP who've given up, who don't want to be engaged with regime. I can see Marc nodding along, and I'll come to you in a second, Marc. And I think it's tricky because these people are people that the prison service sort of automatically thinks they are therefore dangerous or risky because they're not engaging. And I remember a man I met at Earlstoke in the West Country who had been given a very short IPP. He served his original tariff nearly 20 years ago, went to the parole board, was recommended for release by everybody, did not get released. I didn't even get open. And so was told to do a certain number of courses, went and did them again, next second time round, was recommended for release, as he told me, and didn't get it. And the third time that happened, he thought, stuff it, I'm not doing this anymore. And as he said to me, Miss, I'm not an IPP, I'm just going to die in this prison. And I'm not going to play any of these games because they raise hope and then I get dashed. And so I sit in my cell on basic and I smoke weed. And that's what he's done. And when I said to him, I have to say, what if the next time you went to the parole board would give you a time frame where you would get a release date within 2 years? Would that change things for you? And very quickly, first of all, he didn't believe that would ever happen because nothing ever happens. He didn't even know about the license changes in his case. Not that they affect him yet, but he was completely disengaged from everything to do with the IPP sentence. But then, of course, turned around and said, well, Miss, if I had a release date, of course, I'd clean myself up and I'd work towards that. So, I think we need to deal with people on an individual basis and not assume that every person who is not engaged with regime is automatically a dangerous person. I mean, I'm pretty sure I would really struggle in his circumstance to do anything other than what he's done, if I'm perfectly honest. But Marc, I wonder if you have any thoughts on that.
Yeah, we look upon courses like they're always a good thing in prison, and sometimes they're not. And it comes down to trust why people might disengage from wanting to take part in further courses. If we're working with people that sometimes can't articulate themselves in a way that the system thinks is appropriate, can't articulate their way in the way that psychologists want them to articulate their way in, and they go onto a course and they don't tend to get the course or do the course in the way that the guidelines of that course says, then they can get a negative report. And once that's happened once or twice or 3 times, people just choose not to engage because they say, I'm going there, I'm trying to put everything into this course that I can, and I keep on coming out with negative reports, and they're making me do more and more courses. So it's something like once burnt, twice shy kind of thing, and there is no trust. You're asking people to do a course, and they're 15 years over their recommended tariff. To be able to fully give yourself to these courses and in the way that the system wants you to be, you need to be able to trust the process. And sadly, because of the way that people feel like they're beaten down, they don't trust the process. And I've spoken to many people like yourself, Andrea, where they have just said, I'm going to die in prison. I'm not going to cause problems on the landing. I'm not going to be a problematic prisoner, but I'm just going to go about my business. And when I die, I die. I've got no hope of getting out. I don't know no other organisation, business, or structured kind of format where in the world where that would be acceptable.
Yeah.
No, that the state has driven people into this, and it's accepted because these people are in prison. And it's about changing people's perspectives, because some people, I always test my theories out in the pub because they're good, because they're normally it's people that don't really know what they're about the system and stuff like that. And a lot of people say, well, if you can't do the crime, don't do the time. And we would all kind of agree with that in some aspects, but then the crime, the punishment must fit the crime, right? So keep people.
There's a massive disparity between.
So what would that do to a human being? So, and the fact of the matter is, people go on their parole boards and they get another knockback, and their mental health is kicking in, and it's so bad. So they go on their next parole board and they're saying, well, actually, your behaviour's been worse than the last time. And they tend to don't get told, if you do this, if you do this, if you do this, you would get your next parole board. They send down recommendations, obviously, but trying to fulfil them recommendations. So all these types of stuff that are going on, it's all down to trust, why people disengage from offending behaviour programs, especially when you see people who don't do them offender behaviour programs and still get released. Yeah, just because they're doing.
We went up. Lord Thomas and Claire and I went up to with Geordie Gregg from the Independent, went up to Little Hay, to spend a day with IPP prisoners up there. And one of the moments that struck me was in the afternoon session where one of the men was saying, I mean, I think it comes back to what Lord Thomas was saying about that fine line between you got an IPP sentence, or you, if it was a month later or a month earlier, you would have got a standard determinate sentence. And they were saying that, you know, these guys had done exactly the same crime as other people who were in Little Hay, which has got lots of people convicted of sexual offences, but their crime was exactly the same. It's just that they happened to fall within that window of getting the IPP and have therefore had to do X, Y, and Z courses, and other people on standard determinate sentence haven't even had to do them. And then those people are getting released, whereas they're now being held back. And you often talk to professionals as well as to people on the IPP sentence who feel like the courses are being used as another obstacle, so an excuse to keep people inside. And again, that comes back to the sort of very high test of the parole board. And as I think I've said in other fora, you know, I think if you had to have everybody, all the 87,000 people in our prison system released by meter standard, released by the parole board, you know, we just wouldn't be releasing people from prison, because it is intended, that standard for people who have committed really serious offences, and in a lot of these cases that was just not the case. We have time for a couple more questions. Claire, I think there are a couple of questions to ask you. One is a question around a legal case. I mean, you litigate for the whole league. Is there an individual case that could be brought to challenge the IPP?
We have explored legal challenge on this with counsel. Twice we've looked at it, trying to bring a systemic challenge against the IPP sentence. And we have had negative advice, unfortunately, so far, twice on that. It's very difficult, especially with the arguments that we were looking at running in terms of arguing about the sentence being inhumane and degrading treatment, despite all of, you know, the really public things that have been said and are increasingly being said about the damage of the sentence on people's mental health. So as a systemic challenge right now, no, we're still very much open to it. I mean, whether there's an individual that could challenge those aspects, I know there are lots of lawyers looking for those individuals when it comes up, you know, when something relevant comes up. So it's not something we've ruled out. Would definitely be interested in trying, but it's very hard. There's also a real lack of data about the cohorts and their needs, especially their mental health needs for any of those arguments. And so that has been a real barrier in trying to progress a case without any real definite numbers.
Yeah. And there was also a question around racial disparity. What do we know about the racial makeup of IPP prisoners?
We again, lack of data. I don't know about the makeup of those who were given an IPP sentence. What I do know of those unreleased is that the majority are white males between 40 and 49, 78 or 79, I replied in the chat to it, percent of the unreleased are white British males.
Thank you. There's a question here from Steve Raplin. I mean, I think this goes back to the question Laura tried to talk about before, that will end the IPP sentence, reducing it substantially. I mean, our proposals would ultimately see no people in prison on an IPP sentence, because everybody would get a release date and then would be subject to the license termination, subject to meeting that test. So it has been, I have to say, like a tricky balance for the working group to come up with solutions that would both be address the injustice and see release of people on the IPP sentence, which is what we all want, and meet the government's objections to releasing anyone, which is the public protection objection, much as that is kind of difficult to do. So the resentencing exercise where you just finish it all absolutely would be the clearest way to completely end the sentence immediately. The problem with that is that the government has made very clear it has no intention of doing it. So we've really had to come up with something that we think meets those legitimate concerns about public protection in a way that will actually see the devastation of this sentence end for individuals and their families. But it is not as clear, as easy. It's more detailed, as you'll see from the full report, Steve. We have time for another question or two if...
Andrew, I think it's quite an interesting one at the bottom.
Yeah, please.
Sorry, John, to interrupt you. Just saying if their appetite for change within the parole board.
Oh, yeah.
I know you've spoken to, well, we've both spoken to them and there is appetite for change. They're on board with the recommendations that particularly affect them. That first recommendation that Laura spoke to in regards to the set release date. Yes, they support that. And in conversations with them, it's quite interesting that the recent proposals from the Gork review actually have the potential to assist with that, because the majority of the cases that they consider, just numbers wise rather than the length of time, necessarily complexity of cases, are the standard determinate recalls. And if all of those fall away and turn to fixed term recalls and don't require consideration by the parole board, they have mentioned that that would free up a lot of capacity that could then sort of move into this space and give a bit more time to that recommendation. And they already have, for those that don't know, they already set up as part of the action plan and work that's been doing over the last couple of years is a specialist IPP parole board member task force, so that there is a group of dedicated parole board members specifically looking at IPP cases to keep that expertise and the really specific knowledge that they think is required for those cases. So there is definitely already efforts being made by the parole board to help move towards the release of IPPs, and they support our recommendation on that.
And there's a question here from David saying, apropos Lord Thomas's observation that the state has some responsibility for making the risk of reoffending greater, does it also not have serious responsibility for increased risks to the self in custody and IPP sentences imposed? I mean, I think, Lord Thomas, your assessment is, your view is that the state is responsible for the damage of these people and everything that's happened to them. Is that not?
Yes, I mean, I think well, it's not my view, it's what the evidence is.
Yeah.
And I think that is what is critical. I think there's pretty unanimous agreement among psychiatrists and psychologists, who are the people best placed to make a judgment and give evidence on it, that it is the uncertainty inherent in the sentence, which is not for punishment, which it is for everything else, but because you are perceived to be dangerous, and therefore you can never know when you're going to be released. And you haven't been, one must always remember that people who get life sentences for murder, that was part of the original bargain done between the state and its inhabitants, that you'd abolish the life sentence and you would abolish hanging and you would give a life sentence. And so that is part of the punishment. And it's terribly important for people to appreciate this is not part of the punishment. But could I just go back to adding one thing on one of the previous questions, and that is, I do think that this whole business of risk, which is what really we're on about, is the first thing to do is to reduce the risk of people deteriorating further and to give them hope. And that's why it's imperative to get them out of prison. And secondly, there is plainly a prospect that some will be on license for a long time. You can't get rid of the license period. You simply, if someone's been institutionalized for umpteen years, you can't let them go into the community without support. But two things about the licence period I think are very important to stress. One, the test must be rigorous. It isn't going to do anyone any good, particularly if they've fallen into the habits which our society sees everywhere, which is drug addiction or drink. These are things that it's much better dealt with in the community rather than recalling them. And secondly, I do think it's very important that we build on the expertise of the parole board and of some of the judiciary, where actually we have seen in drug and alcohol courts a bond develop between the judge and the person who is subject to an order, where that person feels a degree of responsibility and the wisdom of someone with, and I think I can say this, with a lot of white hair, or certainly greying hair, is much more likely to be sympathetic and more understanding, able to give a better guide through that sort of relationship in getting them off the license. And thirdly, it is critical that if they commit further offences, then they are punished for those offences and not used as an excuse to bring them back. No one else is brought back once they finish their tariff sentence, and there will undoubtedly be some people who will commit serious offences, like we have in the everyday prison population, but you punish them for those offences, not on a preventative basis.
And I think worth remembering that more people serving an IPP sentence have killed themselves in the community than have gone on to commit a serious further offence in the community. So we do have, a real struggle, as Lord Thomas has said, to kind of have people understand who these people are and what risk they really pose. There was a question, the final question we have in the Q&A that I'll answer is, whose fault was this stupid, terrible sentence? I think that was the gist of it. Was that Simon something? Who came up with this terrible idea? Whose terrible idea was the IPP? It was the terrible idea of the last Labour government. So on the back of their own their sentencing review of the time. So that's who ultimately was responsible. Lord Blunkett was the Home Secretary at the time. He has very strongly been clear that that was a misstep, that he didn't understand what it would mean, and has spent a lot of the last 12 years trying to lobby against the continued legacy of that. But that's where it has come from. I think on the positive, I'm going to end on a positive note, which is everybody I've met since I've been in this job and talked to about IPP sentences is on the same page. They all know that they're terrible, that people are suffering, that families are suffering, that something has to happen. And it is one of the few things where you can get everyone in the sector on exactly the same page, whether that's the Prison Governors Association, the Prison Officers Association, the Chief Inspector of Prisons, the Probation Ombudsman, every charity working in these issues, retired judges who I know feel huge responsibility in some cases for IPP sentences that they gave down and don't know what happened to the person. And then obviously the people who've actually lived through it directly or with their families. Everybody agrees that this is a disgrace and it needs to end. It is just a question of working out what the mechanism to do that is politically deliverable. And it is very strongly our view that what we've come up with through this report addresses those concerns about public protection and offers a realistic and safe way for release. So we will continue. This is a time for solidarity and continuing to push forward. We know that James Timpson, the Prisons Minister, is very worried about the IPP population. He's very keen to do much more on it. And he has been open to our conversation, and we understand that the government are considering our recommendations. But we won't be giving up on this or anything to do with IPP, the IPP sentence. And I know from just looking down the list of people I know who are in this audience, we have people who are chairs of IMBs, who are clinical psychologists in prison, who are parole board members, who are retired judges, lots of different people, plus lots of people with lived experience of the sentence. So all of you are really key to helping us get over the line with this. So please, if you're not a member of the Howard League already, please do join us. And I would just like you to join me quietly at home clapping for Mark and Lord Thomas and Claire and Laura for, I'm going to do that, embarrassing, but there we go. Thank you, all three of you, for your wholehearted and work on this report and also on the event today. I'm really grateful to you for sharing your time and your insights with us. We're now going to take a break, I think, from spotlights for the summer. I'm hoping so, because I've got holidays booked, and we don't have any events, so I don't think I'll be corrected by our staff. But we look forward to seeing you in September as we come back to address. In fact, one of the things we're going to have a spotlight event on is probation, because I had a fascinating meeting with NAPO, National Association of Probation Officers, a couple of weeks ago. So we'll definitely be having a long conversation about probation, particularly when the Gork review and the likely sentencing legislation that's coming puts ever-increasing burden on the probation service. So you can look forward to that after the summer. In the meantime, I hope you all have a lovely summer. Take care, look after yourselves, look after your loved ones. And thank you once again to our panellists. And extraordinary, my chairs have not arrived. So I got through, I shouldn't have mentioned them at all. Thank you, everybody. Have a lovely day.